I also would point out that these problems, well, then there's the related problem that Vince raised of sort of the soapbox, the defendant either making propaganda speeches or conceivably passing coded communications to his co-conspirators or to the other terrorists. And again, anyone who's ever, I think, actually practiced and been involved in trials would acknowledge that pro se defendants present uniquely difficult challenges, but courts have tools to deal with pro se defendants. The defendant does not get to treat the courtroom as their own, Hyde Park speaker's corner to come and make whatever speech they want. The trial judge has the responsibility and the tools to make sure that the defendant's courtroom conduct is addressed to the evidence, and if the defendant doesn't abide by the rules, the defendant forfeits the right to be in the courtroom. And the Moussaoui case, interestingly, I think stands actually as an example of a trial judge that showed great patience and great creativity in dealing with a very difficult issue. Ultimately, the defendant entered a guilty plea, which is something that, again, anyone who's ever, I think, prosecuted a criminal case knows is a good thing from a prosecutor's perspective. And the conviction was upheld in really a very thorough and persuasive opinion by the Court of Appeals. I see my time is up, and I know I've really only just barely begun to scratch the surface because there's so many other issues that the other panelists address. I guess, and there's many we can talk about if people have questions. I guess the last point I'd mention is just picking up on Moussaoui and Professor Kelley's comment that, which I think maybe struck me, at least to my ears, as being a little negative, that the presiding judge will have his or her life, career ruined. I don't know that experience really supports that either. Judge Brinkema, who presided over the Moussaoui case, I've had the good fortune to meet her and to talk with her about her experience, and she will tell you that she's a strong believer in the ability of the Article III courts to handle these cases. Judge Kuhnauer in Seattle, Washington, who tried the Rassam case, another very important and difficult case, has testified in the U.S. Senate endorsing the role and the capability of the federal courts to handle these cases. So there are many judges who have presided over very challenging cases who have affirmed their confidence in the ability of our system to handle the cases. Thank you.
Thank you, Mr. Benjamin. We're going to go to a quick period where each panelist has, let's say, a 2-minute opportunity to rebut. And then hopefully turn over most of the rest of the time we have until about 6 o'clock to questions from the audience. We might as well go in the order in which we started. And I think, at least I hope now we can dispense with all the uncomfortable chair shifting and stuff like that. Okay. All right. There you go.
I don't know. This is a proven, a couple of points with respect to, I'll start with Jim. The problem with what we've done so far is that we've left it to prosecutors and judges on a case-by-case basis to make things right, to make it work. And Jim argues that leaks have never come out, as far as he knows, he does in his paper. The problem with all that is you really like dancing on the edge like that. I think about the New Yorker cartoon of a jury that's just aghast. I mean, their tongues are hanging out, they're hanging over the rails, and the judge says the jury shall disregard the last statement. Now, the thing about dancing on the edge, it may be fun for you, I'm sure it's an adrenaline rush, for the prosecutor, but it's just not safe for the rest of us. On the standby counsel in the Moussaoui case, it's not quite so clear, Jim. The post-conviction appeal at Moussaoui, after he was convicted of sentenced to life in prison rather than death, wasn't real happy about that. So he appealed, and he argued that both his plea No, his plea was not properly counseled because he was not given access to the exculpatory information that his standby counsel had, and that was also relevant to his defense. The Fourth Circuit sidestepped that issue. They didn't say that he had no point. He said, well, you knew this stuff anyway because we told you the substance of what the classified was in our prior opinions, and therefore there was cumulative and no harm, and that was it. It remains to be seen whether the Supreme Court will take that and what they'll do with it. I do recommend Jim's report. I mean, it is well balanced, it is fair, it is well written. It has such phrases as SEPA is not foolproof and security breaches may sometimes occur. As those who have worked with it can attest, SEPA is not especially efficient. SEPA does not address the proper outcome when a defendant attempts to represent himself, pro se. SEPA does not address the potential expansion of the scope of classified information that may be sought by a defendant who's facing the death penalty. We could also have a long discussion on whether you can close, you can have silent witnesses and closed courtrooms and all of those things. But maybe that leads into what I know, but I'll do these quickly. I will do Marty quickly. The open trial, closed trial, bleeds into the soapbox question. And you know, I'm really not worried about how NBC is going to handle covering the trials. I'm worried about how Al Jazeera is going to handle the trials, how they're going to cover it, what they're going to broadcast. You know, what could he possibly say? What would the code be? I don't, you know, from his prison cell, the blind sheik who managed to get 47 tourists massacred. You know, so they'll work something out. They'll work out a code. You mentioned the cost. I forgot to talk about that cost. $200 million a year from the time the terrorists first arrive in the city until it's over. If that runs like Musawi, that's $1 billion. Rule of law, Marty, I believe in the rule of law. I think the rule of law is the law of armed conflict. We can have that debate another time. What do our allies think? The French have a specialized terror court. 3 judges, a prosecutor, no trial. They can bring someone in, charge, not indict, hold them forever. They haven't had a serious terrorist attack in 20 years since they put that in place. Before that, there were plans, believe it or not, to fly air jetliners into the Eiffel Tower. And as for the rest of the world that aren't our allies, I mean, whenever I hear the moral suasion argument, I have trouble with it, because I just don't think that the notion that you can apply moral suasion to people who you know, behead their captives and broadcast it on the internet, I just don't think they're amenable to it.